Welcome to Leveraging Inspiration, the Inspired Patent Podcast. McDonald's once stopped a hotel chain from using the term McSleep, even though they did not offer, that McDonald's doesn't offer hotel services. McDonald's doesn't have a trademark for Mc or McSleep. So learn how they won and why it matters for your trademark. I'm Wayne Carroll, your host, here to share valuable insights, stories, and strategies for succeeding in intellectual property. Let's dive into the game of IP and learn how to win. This podcast is not legal advice, but is strictly for educational and informational purposes. Listening to this podcast or reading show notes does not establish an attorney-client relationship. In this episode, we're going to talk about enforcing a trademark that's outside of your direct competitors. In a previous episode, episode 15 of season 13, I talked about how I found 3 companies all using the same trademarks in 3 different product categories. One was a moving company, another was an automotive parts company, and another one was an electric cooperative that sold electricity. They all had the same name, Trico, but they were able to coexist. That happens sometimes, but other times it doesn't work out that way. Oftentimes clients come to me when they see a company using a name similar to theirs and want to know if it is trademark infringement. In this episode, I discuss the 8 trademark infringement factors and how they played out in a case between McDonald's and Quality Inns. In the case, Quality Inns announced that they were going to launch a hotel chain. Now, Quality Inns has multiple hotel brands already, so they were going to add a new hotel brand to their chains called McSleep Inn Hotels. 3 days after they made this announcement, McDonald's Corporation sent them a cease and desist letter. And in this case, when you send somebody a cease and desist letter, one of the things they can do is they can go to court and ask the court to start the lawsuit now and declare that they are the winner, that they are not liable for infringement of whatever this, or the damages that whatever this cease and desist letter says. So that's what they did. Quality Inn sued, even though they're technically, they're acting like the defendant, but they file as the plaintiff, saying, we want a declaratory judgment from the court saying we're innocent in this matter. Now, one of let me go to the trademark factors. So trademark infringement, and this is the same standard when you're applying for a trademark. If somebody else has an existing trademark, the courts, and there are different factors depending on which exact jurisdiction. I'm in Arizona, same federal district as California, the Ninth Circuit. So I'm going to use the factors that are laid out. They're similar in all of the courts, but they're described a little differently, or maybe different numbers. So the first factor is the strength or weakness of the plaintiff's mark. And the plaintiff here is really going to refer to McDonald's because they are the one alleging infringement of their trademark. So McDonald's trademark, it's strong, way up there, probably one of the strongestly enforced trademarks in the world. So that's in their favor. And the way these factors work is any one factor can really sway the court to one side or the other, but they try to look at all of them that are relevant and kind of weigh them. And in a sense, it's a gut reaction decision. So McDonald's has a strong trademark, and in this case, it's actually a famous trademark, which actually gives them more protection. So the second one is defendant's use of the mark. Are they on the same or related or complementary kinds of goods or services? Now, in this case, it's not normal for a hotel chain to offer a restaurant under the same brand. Not really. maybe they'll have a restaurant within their hotel, but they don't go out and do separate restaurants with the brand of their hotel. And restaurant brands don't typically build hotels. So these are kind of complementary, but they're not really in the same category. They're also going to be in completely different trademark classes. So that's kind of against trademark infringement here. So we have strength is up, defendant's use, or how similar the services are, is down. Similarity of plaintiff and defendant's mark, the trademarks. Well, here the only similar part was Mick. We have McDonald's and McSleep, but McDonald's, and this case was many years ago, back in the 1980s, and in the 1980s, McDonald's was just like going wild with their trademark. They had McToys and McShoes and McClothes. They had a whole line of Mick this and that. They didn't have any Mick hotels, but they were able to establish in court that they had basically a line of trademarks that used that Mick prefix, and they went ahead and presented that to court. So they didn't have a trademark on Mick, but that kind of was still, there was some similarity there. So the fourth one is actual confusion. Now, in this case, when Quality Inns, they announced they were going to use it, and by the time the case ended, they had opened one or two McSleep hotels, but so those rare one or two were shut down or changed to a different brand. But at the beginning, there was no actual confusion because they hadn't actually started using it. But the question was, are people likely to be confused? The next one is defendant's intent. And this is where Quality Inns really fell down on their proof, because the intent was the McDonald's used the CEO of Quality Inns' own words when he presented the following to the board of directors. The marketing promise of McSleep Inn is, quote, a consistent, convenient, quality product at a low price. This is basically McDonald's mantra. And he's taking the same mantra and putting it on top of a hotel chain with Mick on it. So he continues, the CEO of Quality Inns says, the marketing hook is the name McSleep, not McSleep Motor Inn or McSleep Motel, just McSleep. The name McSleep should help consumers instantly identify the product for what it is, a consistently clean quality product at a low price. And he later in this presentation to the board says, McSleep is aimed at the entire travel market. Like McDonald's, it is acceptable for the upscale traveler who wants only a good night's sleep and for the economy traveler who wants to save money. So the CEO made this presentation and even compared the McSleep brand to McDonald's brand. And the district court really didn't buy it, that he had no intent to get people to compare McDonald's to McSleep Inn. They just didn't buy it. And so that's where this case really fell down, I believe, for Quality Inns, is that intent. And like I said before, these factors, if you have one that's just blinking bright red, that might carry the day, but it might not if there's others that are just so strong the other direction. The other factors are the marketing and advertising channels. So both McDonald's and Quality Inns are national brands that are going to market in the same channels. And so they're going to be the same customers are going to be encountered by these brands. The next the next factor is the consumer's degree of care. So with McDonald's, they're selling hamburgers. If you're hungry and you want a hamburger, you don't scrutinize, well, I don't know. It's different if you're buying a Porsche, a BMW, and I've often thought, Acura, their symbol on their cars is not that far off to Hondas, and then you have Hyundais that's kind of similar too. But when you're spending $30,000 to $150,000 on a vehicle, you're going to notice those differences. So you're going to be much more discerning than when you're buying a hamburger or you just want a cheap hotel. So the consumer's degree of care is low in this case, basically because they're aiming at the quick, cheap market. And when their degree of care is low, then it's easier for consumers to get confused than when the degree of care is very high. So if it's low priced and people are making quick decisions, then it's much easier for them to get confused than if it's high priced and they're really going to look at that decision. And the last one that the court lists out is the product line expansion. Is it common that someone would expand from one to another? And like I said, that's not really likely, so that's kind of against infringement here. But the other factors, at least especially the intent one, really carried the day. And the court said that McDonald's is entitled to enforce its family of marks that are characterized by the combination of the prefix Mc with a generic word. The name McSleep Inn is likely to cause an appreciable number of the public to be confused by believing that McSleep Inn is sponsored, associated, affiliated, connected, or endorsed by McDonald's. And that the adoption and use by Quality International of the name McSleep Inn was a deliberate attempt to benefit off the goodwill and reputation of McDonald's. So those are the factors. If the public is likely to be confused, then there's likely trademark infringement. I hope this was useful to you and that we answered the question of why did McDonald's win and how it matters for you that your trademark, if consumers are likely to be confused, that's when your trademark is infringed. I'm Wayne Carroll, and this is Leveraging Inspiration.